Welcome to the Financial Planning Workshop on Estate Planning. I'm Fred Smith with the Silicon Valley chapter of the AAII. Let's get started on the topic for today. The financial planning workshops run in a cycle of 10 different monthly events. And we start off looking at the financial planning, the 5 pillars. By the 5 pillars, I mean investing, retirement planning, taxes, risk management, otherwise known as insurance, and that also covers Social Security and the Medicare programs. And then the topic that we're addressing now, which is estate planning. And then there will be we usually have a wrap-up review session to top it all off. So for today, the overview will be, first of all, the estate planning documents. I'm going to touch fairly lightly on most of these because there are numerous law offices, estate planning law offices out there which offer all sorts of meetings, and I guess these days webinars and Zoom events covering all of the legal aspects of these in detail. What I'm going to be covering here is mostly the practical aspects, and we need to do a little of the background information on these documents before we get into the later parts. We'll also look at that, focus on the practical considerations for being an executor on a will or a trustee. We're going to talk about your digital legacy and how you handle that. I want to spend a little time on California's End of Life Option Act and also on philanthropy. And then finally, we're going to look very, very quickly at what I call your all about me exit folder, how to make it easy for your heirs. People tend to avoid estate planning like the plague because it's not a nice topic to think about. So people tend to put it off. All the usual excuses include them, I'm too busy, or the estate isn't large enough. That latter one is actually not a valid excuse because regardless of how little you have, if you have anything, if you own a car or even a small retirement plan or any assets, and also if you have children, you need to get started right away on your estate plan to figure how to take care of these issues if you're not available, not around to do it yourself. One of the other big reasons that people tend to postpone estate planning is because they haven't figured out how to distribute their assets. They don't know what they want to do with it. They don't want to dredge up family conflicts. That's fairly common. When there's money on the table, families do have conflicts, unfortunately. And the final topic I'll put here is that they believe estate planning is a complicated and expensive thing to do. And it's absolutely true. I'm not going to dispute it. However, thinking of estate planning as complicated and expensive is nothing compared to how complicated and expensive it gets if you do not do the planning. So it's something that needs to be addressed and should be in a timely manner. So why do we need an estate plan? We need to designate who's going to get all of our assets when we pass on and no longer need them. We need to look for someone to provide the management of our affairs if we're no longer able to do it ourselves. Anybody with minor children is going to need to appoint guardians for those if they can't take care of the children themselves for any reason. And the same thing goes for any beneficiaries that might have special needs. I've said here that you want to decide whether to probate the estate. Most folks like to avoid probate or think automatically that they want to probate. It should actually be a conscious decision, and most of the time it makes sense to not probate the estate, but there are a few occasions where you may want to reconsider that decision. One of the reasons people tend to bring up all the time for doing estate planning is to minimize taxes, and that's certainly a part of it, but it's not the part of it. It's not the major part. And finally, what we want to talk about philanthropic desires, and this is as good a place as any, in your estate plan to address those. Key elements of the estate plan. This is what I consider the hard part of estate planning. This is the highly subjective, personal part of it. And you basically need to sit down in a nice quiet room and think through all of the questions that are listed here and come up with reasoned answers to them before you start doing, putting pen to paper or calling an attorney or anything like that. And you want to figure, who should handle your finances, if you're unable to do it. What life-sustaining decisions would you want somebody to make for you if you're not able to make those decisions yourself, if you're incapacitated? Have you thought about organ donation? This is a good place to put your wishes on that topic on paper. Who should inherit the assets and how should they be divided? This is the part of estate planning that people normally think about that goes into the will or the trust, but it's only one part of it. Who should administer the estate and actually implement the trust? Who should care for minor children? So all of these things, there are no right or wrong answers to this. Like I said, it's all highly personal, and this I regard as the tough part of estate planning. Once you get that part of it squared away, the relatively easy part of it is actually implementing it. First thing you want to do is take inventory. List all of your assets, list all of your, drag up all of your financial statements from brokerages and banks, have all of those account values conveniently handy. Check what's in any deposit boxes and home safes. And you may or may not need to assemble a multidisciplined team. If you already are working with the financial planner, normally he or she will act as the quarterback and will assemble anybody else on the team that might be needed for a complicated plan. You certainly need an estate planning attorney, and if you do not have a financial planner, the attorney will normally act to coordinate everything and collect up all of the information that's needed. And he will make sure that the documents that are written meet the federal and state laws. You may or may not need a tax advisor, depending again on how complicated your estate is. I don't want to get too deeply into property ownership, but we do need to address it quickly. So what I want to do, first of all, is define joint tenancy, which most of you may know already. It's a form of ownership that is not necessarily used in California that much anymore, but may be used in other states. For property to be held in joint tenant or in joint tenancy, you can have, it's usually just between spouses, husband and wife, but it's not limited to that. There can be 3 or more people, but regardless of how many people are holding property in joint tenancy, the shares have to be equal. Property held in joint tenancy cannot be willed. It passes automatically by operation of law to the survivors outside of probate. So it avoids probate, and that's one of the reasons that people use it. It's normally not recommended for married couples, especially here in California, because when one spouse dies, the other spouse does not get a step up in basis. The only step up in the cost basis goes to the deceased spouse. So that's a drawback. Tenancy in common is very often used for unrelated owners of property, and the shares here can be unequal. They can decide to split up whatever way they want, and this is distributed by will or by trust, as opposed to the joint tenancy, which does not get passed on or willed. Again, though, only the portion of the property that's held by the deceased co-tenant gets a step up in the cost basis. California is a community property state, and that's one of the most popular forms of ownership here. Separate property, first of all, is anything acquired by a spouse before the marriage or during the marriage as a gift or bequest. If your spouse has inherited any property, that will be separate property until and unless it gets commingled with other property. Then it kind of forfeits the separate property category. And after, if there's a divorce, anything that's acquired after the parties separate is separate property. Community property, in essence, is everything else. It's property that's acquired during the marriage, that's funded by earnings or salary. It cannot be sold or gifted by one spouse without getting the consent of the other spouse. And it's usually split equally between the spouses, although it's legally possible to have an agreement where it gets split on equally. That's somewhat unusual. And the surviving spouse gets to step up in the cost basis to the fair market value on the day of death of the deceased spouse. So that's a big reason, a big plus for community property. So now we're going to look very quickly at what a will consists of. A will is a legal document expressing a person's wishes regarding the distribution of his property and electing, nominating an executor to oversee that distribution. And it may, in some cases, state who is to be guardian of the minor children, who's going to take care of any minor children if there's nobody else available. It's effective on death, and that immediately rules out the notion of using a will to provide for your incapacity. You cannot do that function in the context of a will. The parties to a will, all of these main documents have three parties. There's the person making the will, there's the executive who administers and makes it all happen afterwards, and then there are obviously the heirs. Everybody has a will, period. It's no coincidence that there's a big full stop right here at the end of this sentence. If you don't make a will yourself, in other words, you die intestate, the state will write one for you. And what happens is the probate court appoints an administrator to manage your estate and the guardian for your children. These may or may not be the people that you would have picked for yourself, but you don't get any say in it because you forfeited that. And the people that the court appoints might not be the most suitable people for it, in your opinion. The other issue with a will written by the state is that there is no provision for bequest to any friends or charities. The only people that the state is going to consider are basically relatives, either through marriage or through blood. So if a decedent is not married at the time of death, the state will list the heirs in descending order. Will be any children of the deceased, any parents, siblings, and their children, then cousins, second, third, and cousins, and so on down the list. But nowhere on there will there be anybody other than relatives. If the decedent was married, then the property goes to, the community property goes to the surviving spouse. The separate property is divided between the surviving spouse and children. I'm not sure about other states, but in California, that can get to be a fairly complicated, cumbersome formula, and it's way beyond the scope of what we're talking about here. Forms of bequest. This looks like a nice, simple little slide. You've basically got four different ways of passing on, or primary ways at least, of passing on property to your heirs. The first one that most folks think about is a specific bequest. In other words, you might say that you leave your home to your to your sister Jane, or there may be personal property that you want to pass on, like your car or a coin collection or something, and you name the specific person that gets the specific property. You can make a cash request. You can say a specific dollar amount that I want to leave $20,000 to the Red Cross organization or something. You can do a fractional share bequest and say that I want to leave 10% to cousin Joe, and that's a legal way to do it. Or you can do what's known as a residuary bequest, which says that you're leaving this, and this to so and so and so and so and so and so, and whatever's left over, the residual estate goes to Aunt Mary. That again is a legal way to do it. But of the 4 items that I put up here, 2 of them are very easy to deal with and 2 of them are not so easy. The first 2 are very, very straightforward and clean. The second 2 have some buried challenges that aren't immediately obvious until you think about it. As soon as you talk about any percentage of the estate or any balance of the estate, the question immediately comes up, well, how much is the estate? What's the value of the estate? And somebody has to put a value on the estate at the day of death. And any of these folks who are receiving a fractional bequest or a residuary bequest are fully entitled to ask for, in fact, even demand a copy of the value of the estate, of the full accounting in essence. They're entitled to a full report on the value of the estate and to contest it if they don't agree with it. We're going to talk a little bit more about that later on. But you should just be aware that if you are putting percentages into the will or the trust, or if you are using a residuary bequest, that it does give these heirs the right to ask for an accounting. If somebody gets specific property or a pecuniary bequest, that item just doesn't come up. If you're supposed to get $20,000, as soon as you get your $20,000, it doesn't matter what the value of the estate was. You don't even have the right to ask for it. What is probate? It's the judicial process of administering the estate. And the first thing the judge does is his initial task is to validate the will, make sure that it's a legal will, properly written, properly signed, properly witnessed, etc., and to appoint an executor to manage the estate. When the judge appoints the executor, it is usually the executor that you nominated in the will, but it doesn't have to be. The judge is entitled to use his discretion and say that person may be a nice person and may be a great friend, but if he's not capable, competent to manage the estate and to do it properly, the judge has the right to say, no, we're not going to go with that person. We're going to nominate somebody else. Whoever winds up with the task of being executor usually will have an estate attorney to work with and help them through the process. The probate estate includes the gross value of all property owned by the decedent, except, and here we come across some of the things we've talked about before. First of all, the exclusion to probate is stuff that has a beneficiary named in the contract. And that includes life insurance, includes your IRA account or a payable in death bank account, stuff like that. And when you have a retirement account, there'll be a beneficiary page that you ought really make sure you filled out the first level, a minimum of beneficiaries, and probably some secondary or tertiary beneficiaries as well, because the IRA will pass to these people regardless of what is said about it in your will or not. And an IRA does not pass through the will. It goes by action of the law to the beneficiary, as for the life insurance. We've already discussed joint tenancy. That does not go to probate because it's not included in the will. It automatically goes to the surviving joint tenants. And any property held in a trust, which we'll talk about in a minute, does not go to probate. It's one of the exclusions. Here in California, there's also what's called a small estate probate, which is much, much simpler than the regular probate. But if your estate is less than $166,000 and change, it simplifies the task greatly. Above that level, you're stuck with going through the full probate. And also, for that matter, if you hold real estate property or significant property in other states, you may be stuck with doing multiple probates in various states. So what does the executor have to do? Well, the first thing the executor has to do is to file a petition with the Superior Court asking to be appointed as executor and to open probate. And as I've said before, the judge will probably appoint the person named in the will as executor, but he doesn't have to if he thinks it's not appropriate. The executor then has to create an inventory of all the probate assets, getting an appraisal if necessary, has to pay all the bills, file all the tax returns, and do all the regular management of the estate that the deceased would have done were he able to. He has to petition the court to, he has to basically demonstrate to the court that all of the items that go to which heirs and how he arrived at that conclusion, and get their authorization to make the distribution and then to file the final tax returns. The statutory fees for probate are pretty high. It starts off at 4% of the first $100,000, and then 3%, and then 2%. And if you look at it, an estate that's maybe running, $1 million, the probate works out as at $23,000, and it makes a mockery of the notion that people want to write a will instead of a trust because it's cheaper. It only costs a few $100s to write a will, but then if you count in the probate fees that you're going to have to pay, it means that the few $1,000s that you have to write to pay for a trust begins to look like a real bargain. I mean, you get many trusts written for $23,000. The other thing I should have mentioned earlier is that when we're talking about the value of the estate here, it's the gross value, and that's an important number. If you own a house for, say, $1.5 million, and you figure that there's $1 million mortgage on it, so that your estate is only $500,000, that's not true. The gross value ignores all mortgages or any other liability, so the full $1.5 million current value, fair market value of the home would get added in. So exceeding, a number like this is really easy. These are not outrageous numbers, certainly in California, but even across the country. Pros and cons of probate. I said that there are a number of advantages and some disadvantages, and most folks haven't even thought about the advantages. The first advantage is that the court supervises everything. So you've basically got some professional experts looking over your shoulder and checking everything that you're doing and making sure that it's done correctly. It puts a time limit on the creditors and when they must submit their claims and get paid off. So it clears the books in that regard. I think the time limit may have gone up from 4 months. I'm not certain about that, and certainly it may be different in other states, but usually there will be a finite time limit for creditors to submit their claims and get paid. Another thing that may be important in some cases is that if there's a property that's got a cloud on the title, that's going to be making it difficult to pass on. That gets taken care of within and by the court, and whoever inherits the property through probate inherits it with clear title, and that's a significant thing if there are any doubts about the past history of the property. Finally, I've heard it said that sometimes there are disputes between heirs or between the heirs and the executor, and unfortunately, when there's money on the table, these things can happen. But the court is there to settle these disputes and to arbitrate and act as a referee, and it cuts out a lot of the infighting. The disadvantages of probate everybody knows about. Complexity, there's petitions and the county's hearings that go on and on and on forever. Absolute lack of privacy. Anybody can go to the city hall and request a copy of the will and all of the probate documents. Sometimes it shows up in the local newspaper. It's time consuming. The shortest that I know of would be about 6 months. In some places, especially here in the California, the Bay Area, it can take most of the first 6 months just to get the whole thing initiated. And it can stretch to several years or even a decade or more for complicated estates. And the cost is way, way higher than administering a trust in most cases, as we saw in the previous slide. Okay, so we're going to move on from the will and probate to a revocable living trust. A trust agreement is again written to distribute the assets in your estate and to care for your minor children, the same as a will, but it's typically much more flexible than a will. First of all, it can become effective before death, so therefore you can use it to accommodate incapacity. You can name an agent to take care of your financial and legal needs, and for that matter, your healthcare needs, if you become incapacitated and can no longer take care of them yourself. That can be done within a trust, and even though it cannot be done in a will. Also, when you have a second marriage and their children merged from previous marriages, the trust gives you a lot more flexibility than the will in how to take care of these and to make certain that your property goes to the children that you wish it to go to. Again, there are three parties to the trust. There's the grantor, the trustor, and the beneficiaries, and these are self-explanatory. Practical aspects of the trust. First of all, when you get the trust written up by an attorney and get everything signed, first thing that has to happen is that you have to transfer title of all of your major assets into the trust. The house will go into the trust, all of your Schwab brokerage accounts and all of this needs to get moved into the trust, because if the trust isn't funded, then there's no point in spending the time and dollars getting it written up. So you have to fund the trust by moving the title. Very often the attorney will help you with the bigger ones in this regard. When you're refinancing a mortgage, it used to be that you would have to move the home out of the trust temporarily to get the refinancing through, and then move it back into the trust again. I'm not sure if that's still the case or not, or it may do in a few, for a few companies. Normally, a trust will have what's called a pour-over will as part of it. And what this does is take any assets that you own outside of the trust and move them into the trust, if they're not already there. That's convenient for small checking accounts and for small issues. You don't necessarily have to put your car into the trust and stuff like that. However, you want to make sure that all the stuff that's outside the trust does not exceed the $166,000 and change that would trigger a full probate. Because if it does trigger that probate, then you're going to be stuck with the worst of all worlds, not the best. And usually during the trustor's lifetime, he or she acts as his own trustee. You're still in charge of everything yourself, and from that perspective, things go on as normal. Then after your death or incapacity, the successor trustees named in the trust will manage your estate. I want to look real quickly at the federal estate taxes. Over the last 20 or 30 years, living memory for most of us, this is yo-yoed up and down and all over the place. I can remember back in the 1990s, there was an exclusion for federal estate tax. I think it was $125,000 for many, many years. It jumped up to $675,000 in the early 2000s. And then by 2017, it had gotten up to $5.5 million. And the maximum tax rate, again, was all over the place, ranging from 35% to 55%, except in one calendar year, 2010, the federal estate tax was repealed. So it was basically zero. So for anybody who was foresighted enough or had the good grace to pass away in 2010, his or her heirs would be forever grateful for the lack of estate taxes. I'm not certain. I think George Steinbrenner, the owner of the Yankees, was one of those people. And I think there was a huge, huge estate with what would normally have been huge, huge estate taxes incurred that got a free pass in 2010. The current estate tax have got changed in the end of 2017 with the TCJA, the Tax Cuts and Jobs Act, and the exclusion jumped to 11.58 million per person, twice that for a married couple in 2020, with a maximum rate of 40%. And all of that sounds nice, and you say, well, for a lot of us, that exclusion means I don't have to pay any estate taxes. The problem is the TCJA, this part of it sunsets at the end of 2025, and then you revert back to the 2017 law and the 2017 numbers. And it really surprises the heck out of me that something as long range as estate planning can have these huge step function anomalies built into the projections for the future, making it extremely difficult to do any planning. You can possibly think of this as the Attorney Full Employment Act. California doesn't currently have an estate tax or an inheritance tax, but I put a little question mark at the end of that because there's a proposal that keeps coming up in Sacramento for a 40% tax on all estates that exceed $3.5 million, but there'll be a full credit for the federal estate tax, which you'd be paying above the $11 million limit. And it means in essence that you'd be paying 40% on the difference between the two exclusions. But the difference between the two exclusions would be, it's about $8 million. So 40% of that is over $3 million. That's a big hit. Now this has been proposed numerous times in the Senate, and it's been voted down. There was a move to put it on the ballot, I think, for this coming November, but that failed. So it will not be there for this calendar year or probably next year. But my guess is that it's likely to come back at some time because it's a sort of zombie thing that just won't go away. And then with the huge debts that we've been incurring for the past couple of months, I think this is a likely candidate to come back. Next document we need to address real quickly is the durable power of attorney. For this covers financial and legal issues, and it means that whoever is nominated as your agent gets to pay all your bills for you and write the checks. They'll have access to your online accounts, manage all of your investments, and do all of the stuff that you normally do for yourself. And there are two forms of this. It can be an immediate DPA, which means that as soon as it's signed, the agent can immediately start taking over for you. Doesn't have to, but with your sanction and oversight, can start immediately. And the other form is known as a springing power of attorney, and that becomes effective on the determination of your incapacity, usually by two doctors agreeing that you're incapable of managing your own affairs. The durable power of attorney document terminates on death. So if you've been managing the estate up to the time of death, on the day of death, you no longer, as durable power of attorney agent, have the requirement to do that, but you may suddenly be kicked into action as a trustee because very often it's the same person that gets nominated for both. How should you pick an agent? Most folks take a relative or friend. You can have a bank do it for a fee. They're probably going to require their own form. The most important characteristics, obviously, are that the person be trustworthy, competent, and knowledgeable. What's often overlooked, though, is that they need to understand and respect your philosophy. If you happen to be a modern portfolio theory kind of buy and rebalance investor, fairly conservative, and your agent that you nominate happens to be a day trader at the other extreme, they need to understand loud and clear that it's your wishes and your account that they're managing, and they should leave all their urges to boost your income by day trading aside and do it in the manner that you want. You can name co-trustees, two, three or more trustees if you want. That's probably not a bad idea under some circumstances. If there are 2 or 3 children, that you may want to name them, but just be careful that if there are any differences in opinion, that they can iron them out. What you probably want to consider doing is making a ruling that the majority vote, if there are differences, counts, and do not believe it that it has to be a unanimous vote, because then any one child that happens to have a dislike for a certain plan of action can veto it, and then you could get, if you're not careful with picking co-trustees, you can get frozen, have the account frozen. And you can also name successor trustees, and that should probably be done too. For healthcare, you can also name a healthcare power of attorney. The same sort of rules apply. This is somebody who is empowered to speak on your behalf when you're no longer able to do it. You probably want at least one alternate agent named, and typically this gets activated again when two doctors agree that you're no longer able to make your decisions for yourself, and again it expires on death. I think that some healthcare power of attorney forms, modern ones, may allow you the right to dispose of the deceased remains. That's a minor exception to the expires on death. Living will lets you make your wishes known regarding, resuscitation, artificial respiration, and all of these other things. And it's good to document all of this while you can, so that if you're seriously incapacitated, it's well known what your wishes are. It also covers donation of organs. And in California, I guess in most states, the power of attorney for healthcare and the living will tend to get rolled into a single document, which is an advanced healthcare directive. Again, who should you point? The rules are much the same. Family or friend, make sure they're competent, knowledgeable. You want somebody who is assertive enough to argue with the doctors if they think that the doctors are recommending a strategy that would not meet your requirements or your wishes. But you don't want anybody who's overly controlling. So it needs to be somebody who is used to taking a firm position, and that you feel is going to stand up for your wishes. You should include a HIPAA release to allow them access to all of your medical data, because otherwise the doctors of the hospital may not be willing to release a lot of the information to you. And you should discuss your wishes with your agents beforehand so that they're very, very clear on what you want, and give them a copy of the document. A letter of intent is a useful nuts and bolts thing to add into your documents. It's not normally a legal document, although it can be referenced in the will and take on some of the forms and characteristics of a legal document. But in case of your incapacity or death, it defines all the day-to-day stuff that makes it easier for your agent to manage your affairs. How to get access to your electronic data. It allows you, for example, to define clearly the pre-arrangements you may have made, funeral arrangements or cremation arrangements. And it allows you to write your own obituary if you choose to do so. And the last item on the list is to give you a list of all the people that they would like you to contact, and the contact information. Typical duties of a trustee. First of all, it's a great honor to be named as trustee, but before you rush to accept, think very, very long and hard and carefully about what's involved. There's a lot of hard work. It's all time consuming. And basically for the first week, as we'll see in a minute, it's a full-time job and then some, and continues as such for many weeks. It's a major responsibility. You need to be careful, what you're doing in signing documents, because there can be some legal liability, although that's somewhat limited, but you do need to be careful. You may or may not be compensated. You're allowed to be compensated for the task that you're doing, and normally the trust or the will spell this out. But if you happen to be, for example, the sole heir or something like that, and you're acting as the executor, it may make sense to forego the compensation directly if you're going to get it anyway in the form of the legacy. It's possible to resign the trust afterwards, but it's very, very difficult. And what the main takeaway from this slide is that if you think there's any possibility you would not want to do it, please, please, please make that decision up front before you accept. And once you accept, make it a firm commitment that you will in fact do it, because once you've inherited the task, the job, you cannot just walk away from it. You have to get a new trustee, and that new trustee has to accept the task and take over and be installed before you walk away. You can't just leave the chair empty. And that can be difficult to find such a person and to make it all happen. The immediate tasks of the trustee on death, are the obvious ones you would expect. Pardon me. You want to verify all the details for the death certificate. You may only need 1 or 2 copies of the death certificate, but most folks suggest that you order at least 5 and maybe as many as 20 for a complicated estate. They're fairly cheap. I remember when they were $3 or $4. I think they're up to $12 or something nowadays. But typically for local banks and brokerage and so on, you bring in the original, show it to them, they'll run a Xerox copy and hand you back the original. That's why I say you may only need 1 or 2 of them. If you're dealing with out-of-state financial houses or real estate, you may have to mail them an original and you may never get it back. And rather than have the hassle of looking for more later, I normally make a suggestion that you make sure you order plenty of them up front, even though you're going to wind up with far more than you really need. You have to sign off on all the funeral arrangements and everything. You need to let the family and friends know, get them copies of any of the documents after the fact. You need to let the Social Security office know that of the death, although they normally find out pretty quickly anyway, and that's tied up with Medicare, so that's all the one thing. If there are any pensions or annuities involved, you need to let them know. Notify the banks and any brokerage accounts, and obviously close out any nursing home accounts. Banks and brokerages normally are going to put a 40-day freeze on the accounts as soon as they find out, based on state law. Legal issues for the trustee has to take care of. First issue is to make sure you have an estate attorney lined up. Usually, but not always, that's very often the attorney that drafted the will or the trust in the first place, but it doesn't have to be. You can go, if they happen to be out of town, or if you happen to have another local one that you work with more easily, that's fine too. You have to coordinate all the legal issues with him, which basically means collecting up all the documentation that he needs and providing that to him. I need to file a new tax ID for the trust, and very often the attorney will do that for you. It's not a big deal. It's just a hassle, but it's a fairly simple form. And the banks are going to need, and the brokerage accounts are going to need that new tax ID to reopen the accounts that have been frozen, because they get to be reopened under a different name and with a different tax ID. When you're signing documents, I believe that the proper form in most cases is to sign it your name, trustee, and adding the word trustee in there absolves you, or makes it the responsibility of the trust if there are any errors rather than you personally. But this is one of the areas where you need to be careful that you don't have any legal liability yourself, or to minimize the potential for legal liability for yourself. Sometimes there's an irrevocable trust for a predeceased spouse. If the deceased spouse is the second to die, there may be an irrevocable trust from the first spouse hanging out there. And sometimes it makes sense to approach that trustee and see if he or she wants to vacate that trust and let you handle both. That's just for convenience, and it doesn't have to happen, but it may be worth at least approaching the other trustee and seeing if it makes sense. For financial issues, you need to collect up all the documents. I usually found it easiest to transfer them to my home and sort them all out there. You're responsible for the safety. So if the deceased was the second to die and there's basically an empty house, you may not want to leave any important documents or valuables there in case it gets broken into. So it can be easiest to just bring the documents to your own home and office and sort them out there. The bulk of them you want to get rid of, and hopefully you'll be able to shred them. But you have to hang on to all of the important stuff for 3 to 7 years, and that can still be quite a few large document boxes. As I said, for the bank accounts and brokerage accounts, they'll get frozen by the state for 40 days. Then you have to use the new tax ID and an affidavit to reopen the account with the new ID. In the meantime, you have to pay all the bills, your gas and electric bills and the landscape bills for the guy that's cutting the lawn and all that good stuff. If the bank account is frozen, you may need to do this out of your own personal account and then get reimbursed later. And don't forget, when you're managing the portfolios that the prudent investor rules, it's usually best to just do a diversified portfolio, recognizing that you may need to withdraw fairly hefty sums of money in a fairly short time. So don't do any real long range investing, and certainly don't even think about any of the higher risk day trading type of stuff. Accounting issues, there are a whole load of stuff here that needs to be taken care of. I find that it's very often best to retain an outside accounting firm if the estate is anyway complicated at all, because this makes it easier to report to the heirs. If they get an accounting of the value of the estate on the day of death on the letterhead of an accounting firm, they're less likely to dispute it than if it's numbers that you pull together yourself. Usually the attorney will recommend that you only distribute 60 to 80% of the estate to the beneficiaries. You want to hang on to the remainder part of it for at least 3 years in case there's an IRS audit or any other expenses or liabilities come out of the woodwork. And at the end of the 3 years, you can then distribute the remaining balance of the estate and close out the estate. Bottom line is keep meticulous records with all the meetings, everything that, all the phone calls, all the transactions. If it isn't written down, it never happened. Selling your home, this is all the normal stuff for selling your home, the same as if it were your own home. The only thing that I would flag on here as being a little different is preparing for an open house. You're going to wind up having an estate sale at some point if this is the second spouse to die. If you want to do the estate sale yourself, well, first of all, you need to pick through it for all the specific bequests that go to the specific heirs and take care of that. And whatever's left, you need to dispose of. And if you're having an estate sale, there are 2 or 3 ways of doing it. One might be to have some auction house come in and take what they think that they can sell, and then get rid of the rest of it as best you can. Sometimes I find it's useful to have a professional estate sale agents take over the responsibility, and they'll put in a week or 2 of hard work arranging everything, doing an inventory of everything in the house, getting it all sorted out and nicely displayed, and getting price tags and everything on it, and arranging for an estate sale on weekends and stuff like this. They first blush, it looks like they're expensive. They'll typically ask for 30, 35, 40% or more of the total proceeds. But trust me, I think for a lot of cases, it's a bargain. They put a lot of work into it, and if they don't do it, you're going to have to do it yourself, and it really chews through a lot of your time. They can also be made responsible for taking the unsold items to charity and the junk to the city dump. And again, they'll also be responsible for leaving the house, clean and ready for close of escrow. Again, document everything. How long should you keep records? Some folks say that you should keep tax records forever. I think in case of fraud, the IRS has the ability to go back forever. But if you don't anticipate fraud to be a case, typically you keep tax returns for 3 to 7 years. For any items, transactions, closing statements and stock trade confirmations, stuff like that, normally they say to keep it for 3 years. Some of the stock stuff, you probably don't need to keep the paper stuff anymore because most brokerage houses now have all of this online, so you can access electronic versions of it. but you need to have access to the data in one form or another for at least 3 years. This can be, again, you may be keeping some, multiple boxes, multiple document boxes with a ton of stuff here that you need to hang on to for a while. Practical tips for the trustee. If it isn't written down, it never happened. Document everything and then do it again. It's useful to communicate with the beneficiaries on a regular basis, at least annually, because otherwise you're going to keep getting phone calls and letters and emails saying, when do I get my bequest? What do I have to do? Or why is it late? And keep those communication channels open. It's the easiest way to solve any problems. Be careful to disclose all major transactions to the percentage and residual beneficiaries. Remember, we talked about this way at the beginning. You need to get their written approval on stuff that affects them. And this can be a huge thing, if you get blindsided by it. You may be selling the home and have close of escrow scheduled for next Friday, and it's tough if you have to make a phone call to the other principals after the close of escrow and say, well, I'm still waiting to get the approval of the Red Cross legal department in Chicago for the 5% donation or the 5% of the estate that they've been promised. And the main attorney's out on vacation and won't be back until for 3 weeks. So we're sorry, we're going to have to delay the escrow. But that may sound extreme, but stuff like that can and does happen. If you need to get the written approval of these beneficiaries, some of them will be very willing to work expediently with you, but some of them, especially in any of the legal departments, may drag their heels a little bit. They don't necessarily move that quickly. For the specific beneficiaries, it's a lot easier and you don't have this hassle. In the digital world, you need to make sure, if you're the agent, that you have access to all of the the stuff. Well, you know this stuff better than I do, what all's involved. But there's a ton of digital stuff out there, and you might want to make sure that your trustee or your agent for power of attorney knows how to get into your Schwab account, what to do with your Facebook account. What I have found, and I'm almost reluctant to put this in writing, but I think it's important enough that I did, against all security rules, keep a written list of all IDs and passwords in clear text, obviously in a very safe place known to your durable power of attorney, agent, and trustee. Or the alternative is to use a digital password safe. But even if you have a digital password safe, you don't get around the problem, because there's a very secure password access to that safe. It may only be the one password, but that needs to be available easily and readily to your agent or executor or trustee, so that he or she has access to your accounts. And I think it needs to be done very, easily understood, which is why I said, to write them down in clear text. But obviously, having done that, it does need to go in a secure place. My own personal feelings is that you're more likely to pass away and leave a mess to your heirs to sort out passwords and IDs and so on, than you are to have somebody crack your email password and misuse it. And make sure that the person you nominate is given the authority and the will to do this, because you want them to be able to get into your Schwab account or your Fidelity account or whatever it is. You want them to be able to get into your bank and pay all the bills and stuff like that legally. If you don't give them authority and the will, they're probably going to wind up bootlegging it just for the sake of expediency, and either using, if they're inheriting your cell phone, they probably have access to all of that. And they can get on the accounts without necessarily letting the financial houses know that they're not the person that they think is accessing the account. Long-term digital strategy: so organize everything, back it all up, make sure it's protected with strong passwords, and include a section in your durable power of attorney listing all of this stuff and giving the agent the authority to do it. I want to spend a couple of minutes on the California End of Life Option Act and the Right to Die law. It was implemented way back, well, officially went into effect in 2016. There was a legal challenge in 2018 because it was passed in special session, which put a sort of a cloud on its validity, but that was overruled by the state court, the Supreme Court, and it was reinstated. In essence, California was the fifth state, the other was being Oregon, Washington, Montana, and Vermont, to have a right to die law. It means the requirements for this: you must be a California resident, be an adult, have the mental capacity to make your own decisions. You have to have two physicians diagnose terminal illness, and then there are requirements as to how you make a written and a oral requests to use this. And then you must have the physical capacity to self-administer the drug. There are two items on here that we might have glossed over a little bit that are kind of important. You must have the mental capacity to make your own decisions, which means somebody with dementia or Alzheimer's disease or whatever probably cannot use cannot avail of the right to die law. And the other thing is you must have the physical capacity to self-administer the drug, which means that comatose patients can't avail themselves of the law. And the other thing, of course, is that it can't be done through a power of attorney for healthcare. So the law may not be quite as useful as some folks might have hoped. I want to cover philanthropy real quickly because a lot of folks include this in their estate planning documents. You can make a simple bequest in a will, obviously. A lot of folks nowadays find that donor-advised funds work great because what you do is you make a contribution to the donor-advised fund, which gets you an immediate tax deduction for the full contribution, but you can delay when you make the grant from the fund to the charity, and that can be done in different bits and pieces at a later date. So you're separating the two functions, and that can be very useful. You can take make the contribution and take the tax deduction in years when it's advantageous to do that, and that can include doing a lump sum in 1 year that's going to get distributed over many subsequent years. On a more complicated basis, you can consult an attorney to do charitable trusts. There's a charitable remainder trust, a charitable lead trust in one case, and one receives the income during your life and the remainder gets passed on to the charity. And then for the charitable lead trust, it's the other way around. Or you can go for broke with the private foundation. That can get very complicated and can be somewhat expensive, not just to set up, but to administer. What I call the 5 big questions relating to philanthropy. Rather than just cut a check to Red Cross without thinking any more about it, what some folks like to do is how do you get the biggest bang for the buck? And the question there is, how many people does it benefit and by how much? Is the donation going to be effective in doing what you want to do? One way of measuring this is a unit of health, really. It's called a QALY, a qualified adjusted life year. And that's equal to the percentage improvement times the number of years. I give a quick example here. If you want to donate, a few $100, let's just say 100 mosquito nets at $4 a piece, that would give a 10% improvement to to some village, let's just say in Africa somewhere. It may improve their lifestyle by 10% by giving them better ability to get more sleep and avoid some of the malaria issues and stuff like that. You might say that they last for 5 years. You're talking here about 10% of 5 years would be half a QALY for $4 a piece, $8 per QALY. You won't get anything nearly as cheap as that, in the U.S. You're going to be talking about hundreds of dollars, thousands, tens of thousands of dollars per QALY, depending on what you do or how what charitable ventures are things that you're interested in. mean, for example, if you wanted to make a donation to your alma mater, for funding a student or something like that, if you're making, tens or hundreds of thousands of dollars contribution, something like that, it may be only for a few qualities. So you wind, for one person, you may wind up with, 2 or 3 orders of magnitude higher than this. The other area you want to look at is this area being neglected? If you did not make this contribution, is anybody else going to do it, or will it happen? And some folks like to look at the high impact opportunity, which are probably also high risk in some cases. But all of this relates to stuff over and beyond the normal contributions that we make to the various well-known national and international organizations. They're not necessarily the most efficient way to do it. I put together a highly subjective chart here, which is a little bit of an eye test, but you probably want to make up your own. But this is what I said with a nod to Abraham Maslow and his hierarchy of needs. If you start off on the left side at the bottom here with the basic needs, the fundamental needs, which would be safety and shelter. If you're being chased by a lion, nothing else counts, in terms of food or healthcare or education or something like that, and until you get these lower order needs taken care of. And then as you go up the scale on the left, you get to your hopes and dreams and long-term aspirations. Across the top, we have immediate needs, which can be, seconds, minutes, hours, going all the way days, weeks, months, out to long-term goals, which can be decades. And in general, you get much more bang for the buck down here in the bottom left corner, because the qualities are a few dollars a piece down here, and as you go up this slope here, the cost per quality goes up until you're talking about thousands or tens of thousands up in the top right hand corner. Rather than take my highly subjective version of it here, you probably want to make up something equivalent to this yourself. But I just wanted to get you thinking about the concept of having cheaper qualities in one area and more expensive in another area, and making a conscious decision as to which of these types of areas you personally feel most comfortable supporting with your charitable dollars. Last item I wanted to cover, and this is going to be very, very quick, is your All About Me exit folder. It's the best gift that you can leave to your loved ones. Make up a big folder and collect all of the documents together, store it in a secure place, and make certain that your executor or trustees knows where to find it. And I'm going to go through it. There are slides here for the various stuff that goes into it, but I've discussed all of these already, so I'm not going to do it now. I know these are the documents that you should put into it. For your financial planning records, well, on one of our earlier workshops, we discussed investing with your personal investor profile and your investment policy statement. It'd be good for your heirs to have access to these so they know what your style is for doing investing, and include all of the documents on here that you would normally, that they would normally need. Make it easy for them. Healthcare, the same thing goes. Collect whatever documents that you have, and list the people and the doctors involved, so that again your healthcare power of attorney or an agent will have easy access to the information they need. Other documents could include, again, we're getting down to the personal stuff, your IDs and your passwords, copies and location of your driver's license, passport and stuff like that, marriage certificates. Review the plan regularly. Normally they say every 3 to 5 years, if there aren't any big changes other than the law changing. That's one of the biggest things that happens within the 3 to 5 years. But if there are significant changes like the death of a spouse or divorce, etc., moving out of state, state laws differ, so that would trigger another opportunity or requirement to do a review. Purchase or sale of a business. I've given you a list of further reading here if you want to dig into any of these issues more deeply. One thing I would draw your attention to is McCaskill's book, Doing Good Better, for anybody with fairly significant philanthropic desires, this is a great place to start. And it again defines the concept of the quality and how to use it to make your judgment as to what you want to support. I've given you websites here. This includes obviously our own Silicon Valley local chapter website, where all these slides are available, along with information on our other events and everything there is to be known about us. And finally end up with a mandatory cartoon, which says, "A raise in my allowance is fine, Dad, but what I'm really after is power of attorney." Thank you for listening, folks, and good luck with your venture. This talk is a shortened version of a 2-hour interactive workshop that we webcast live. And if you're interested in the longer version, you can find details on our local chapter website at www.siliconvalleyaaii.org. You have the website up here if you need to note it down. We're also on Meetup and on Facebook, and you can see some videos of some of our previous events. You can call them up on the YouTube channel. I've given you my email address here as well, in case you have any comments or questions or anything like that that you'd like to follow up on later. This is our standard disclaimer. I'm not an attorney, so if you have any questions or if you have any major decision that you need to make, please talk to an estate planning attorney before making any major commitments. We try to keep the content of what we're showing here accurate, but there may be some errors. I believe that it is in fact accurate, and the material that I'm presenting here is not necessarily that of the views of the local Silicon Valley chapter of the AAII or of the national organization.